The Supreme Court of the UK. The Supreme Court of the United Kingdom is the Supreme Court in all matters under English and Welsh law, Northern Ireland law, and Scottish civil law. In the United Kingdom, it is the court of last resort and the highest appellate court. It has jurisdiction to resolve disputes relating to devolution in the United Kingdom and concerning the legal powers of the three devolved governments in Scotland, Wales, and Northern Ireland, or laws made by the devolved legislatures. The Supreme Court was established by Part 3 of the Constitutional Reform Act 2005 and started to work on October 1, 2009. It assumed the judicial functions of the House of Lords, which had been exercised by law lords, the 12 judges appointed as members of the House of Lords to carry out its judicial business. Its jurisdiction over devolution matters had previously been exercised by the Judicial Committee of the Privy Council. Because of the doctrine of parliamentary sovereignty, the Supreme Court is much more limited in its power of judicial review than the constitutional or Supreme Courts of some other countries. It cannot overturn any primary legislation made by the Parliament. However, it can overturn secondary legislation if, for example, that legislation is found to be ultra vires of the power in primary legislation, allowing it to be made. To learn what is primary and secondary legislation, you may watch the relevant section of public law on our website. Furthermore, under Section 4 of the Human Rights Act 1998, the Supreme Court, like some other courts in the United Kingdom, may make a declaration of incompatibility, which means it can indicate that it believes that the legislation subject to the declaration is incompatible with one of the rights in the European Conventions on Human Rights. Such a declaration can apply to primary or secondary legislation. The legislation is not overturned by the declaration, and neither the Parliament nor the government is required to agree with any such declaration. However, if they do accept a declaration, ministers can exercise power under Section 10 of the Act to amend the legislation by statutory instrument to remove the incompatibility, or ask Parliament to amend the legislation. The UK Supreme Court has a fabulous website which is quite educational in nature. I do encourage you to visit that website often to learn more and more about this court. As part of this lecture, you must also watch the introductory video on the Supreme Court's website. Click on the link that will take you directly to the page that has a link to the video.